taking it, please do so. It's never good to pay more than what something costs at the top of the day. So make sure you register. Appreciate it. So we have been going through conflicts. We're sort of still just in the beginning of it. We did the previous chapter, we sort of introduced us to the notion of conflicts, and we talked about Rule 1.7. And we're still doing the same thing now, but we're taking it and applying it in a particular practice context. So that's what we've been doing. We've been talking about joint representation. We're going to build upon that today by looking at two cases. One, the corporate scenario, building back on our hypo with Dorian Hathaway. We're going to do that again. And then a series of hypos focusing on joint representation in the criminal context, actual case. So if you know the actual criminal case, just sort of ignore the result if you know about this case. And we're just going to be focusing on the rule 1.7 and if something is consentable or not. So we're still dealing with those basic questions that we started off with. Does a conflict exist? Is it directly adverse? No, if it's not directly adverse, you still ask the question, or is it materially limited? If it is, we still ask the question, is the conflict consensual or not? In other words, you go through those steps and you say, can the lawyer provide reasonably competent, does the lawyer reasonably believe that she can provide competent and diligent representation, and then informed consent? And that's assuming that you are not in the same action, on the same side of the V, it's not prohibited by law, and all those things, and then informed consent. So that's essentially just running through what 1.7 does. So notwithstanding this conflict, you ask, do I reasonably believe that I can proceed and offer competent and diligent representation? Notice competency and diligence are provided under the rules. Competency is Rule 1.1, diligence is Rule 1.3. And then from there, it's not prohibited by law, you're not on the same side of the V, and then informed consent. If you do all of those things, then you may be able to proceed. But today we may see that even if you do all of those things, perhaps the relationship is so flawed, the conflict is so devastating to the core relationship between attorney and client that it's actually non-consentable. So there will be instances, most of the time you will be able to get informed consent and move on with the representation, but there may be rare instances where the conflict is so devastating to the core of the attorney-client relationship that you can't paper over it with informed consent. And we may see that today. So where we left off in chapter 7 was we started talking about the organization as client, and you see that shown on page 291. And we made a number of points. The attorney actually represents the entity itself. Of course, the entity can't do anything without natural people moving it forward, but if you're in a scenario where the people think that you actually represent them, you have to make it clear, particularly where interests might diverge, that you represent the organization, not the individual constituent. There is a provision, though, where a neutral organizational official can give informed consent, and you may represent the officers as well as the entity itself, and that's under Rule 1.13G. So that's another example of informed consent, and you're representing the actual individuals and the entity itself. So that would require informed consent because a conflict could arise and then there would be problems. But the lawyer representing the organization may also represent any of its directors. With informed consent. Because on some level, that's a classic joint representation scenario as well. So that's just an example of that. And then before that, we just went through Rule 1.13. You see the chart, but you have a number of scenarios. The first thing 1.13A says is that you represent the organization. So you're doing things to make sure that you act in the best interest of the organization. You see that on the chart on page 291. Then there is this provision under B. It's really called reporting up. So notice how this works. 1.6 is still sort of in the background of your mind as a lawyer. You have to protect this information, confidential information. Your goal is to protect information that is internal to the organization, those confidences. Make sure you preserve those confidences. So before you even have the option of reporting out, you have to work your way up through the corporation if you see something wrong. Either an intentional engagement in violation or something that could be imputed to the organization. And if you look at Rule 1.13B, it says you have to know of a violation to the corporation or one that could be imputed to it that's likely to result in substantial injury. And so, it's too long to write, but substantial injury. Then the lawyer shall proceed as is reasonably necessary in the best interest of the corporation. That means working your way up all the way to the highest authority that can do something for resolving this matter. So substantial injury to the organization. And this is just paraphrasing the rule. Then lawyer shall proceed. So you see a lot of deference is built into this rule. Deference to the judge, to the corporation. That's interest. So paraphrasing, if you see that there's a substantial injury to the organization that could result from conscious intentional engagement in conduct that amounts to a violation that will hurt the organization, substantial injury, or actions that can be imputed to the organization, then the lawyer shall proceed as reasonably necessary in the best interest of the organization. And this includes moving up the ladder within the organization to the highest authority authorized to act. Now suppose that doesn't work. What do you do then, according to the rule? It says if your reporting up to the highest authority doesn't work, you have the option of reporting out. But notice how this rule is structured. It's almost layer after layer before you really can make the decision, and even then it's like may reveal. So this is an exception to the confidentiality rule as well. You don't have to know rule numbers. I'm just putting this up so you'll go back and look at that. So say you work all the way up internally in the corporation, everybody's ignoring you, no, that's not really happening, don't worry about it, okay. Then you notice people stop talking to you at least about that, and your workflow sort of moves in another direction, so you don't have access, because you know things are going wrong. And so your first step of moving all the way up fails. Then you go to rule 1.13c. Despite the lawyer's effort, the highest authority that can act insists upon or fails to address this issue that you're bringing to their attention. So you've done everything you can. You have two components in letter C. Reporting up fails. Again, just paraphrasing the rule. Reporting up fails. And you see this on the chart, but look at the rule as well. You see this on the chart on page 292. The lawyer reasonably believes that the violation is reasonably certain to result in substantial injury to the organization. Then the lawyer may reveal, but only if the lawyer reasonably believes it's necessary to prevent substantial injury to the organization. That's not reasonably, is it? So reasonably believes that the violation is reasonably certain to result in substantial injury. Then the lawyer may reveal whether or not it's prohibited by 1.6, but only if and to the extent the lawyer reasonably believes necessary to prevent substantial injury to the organization. How does that work? So this rule is drafted almost in such a way that you have a discretion not to disclose, almost. And the Lord reasonably believes that. Reasonably certain. And it's substantial injury, so the lawyer has to figure out what that is. So it's going to have to be something more than you don't like the CEO and you think she makes a lot of dumb decisions, business decisions, and it could hurt the company's bottom line. That's fine. It's not a violation of law. It's not something that could be imputed to the organization to damage it. You're still looking out for the best interest. But if you read the comments, under no circumstances should you, as a lawyer, substitute your quote business judgment for that of the governing body. And so I think that's why there's so many hurdles. Reasonably believed, reasonably certain. So all these layers, after you report out that fails, and then you reasonably believe that the violation is reasonably certain to result in substantial injury to the organization, the lawyer may reveal. Doesn't say must reveal, may reveal, but only, this is even another hurdle. So you have this deference, but only if the lawyer reasonably believes again. Reasonably believes it's necessary. Substantial bodily harm again. Not bodily harm, substantial injury. Substantial injury. So a lot of hurdles. We really want you to report up and keep this information within the corporation. And if you do report out, it's an exception of 1.6, but it's deferential, permissive, and there are a lot of hurdles. So reporting up has to fail. The lawyer has to reasonably believe that the violation is reasonably certain to result in substantial injury to the organization. Then the lawyer may reveal, but only if the lawyer reasonably believes it's necessary to prevent substantial injury to the organization. You see that on page 292. Now, letter D just says you don't reveal if you are in an investigation or helping the organization in some way. That's letter D. Letter E just says if you withdraw or are terminated as a lawyer because of your efforts to bring about disclosure or dealing with an issue that may be a violation on the part of the organization, and you're fired or something, then you can reveal, you can take steps to inform the board of directors about that firing. That's letter E. Letter F says that you have to explain that the organization is your client if someone comes to you and they think that you're representing them just because they work for the organization. And then letter G says what I said earlier, that you can represent the organization and directors with informed consent. So all that was just to illustrate there are many limitations in how you do this joint representation. Here, the special situation of the conflict is you're representing the organization, and those interests are certainly going to diverge at times with the individuals who work for the corporation. So that brings us to our problem with client subsidiary on page 299. So this brings us back to Dory Hathaway. And we saw that in problem 6, and we did some things with just to show directly adverse, even though the matters were unrelated, what that meant. And now we're presented with another scenario. So on top of page 299, we have a scenario where another firm is now representing Pearl Bus Company, and Hathaway was seriously injured when the bus hit her. We continue representing her. So we have Dory Hathaway against Pearl Bus Company. I'm going to put that on the board. So that's good. But unbeknownst to us, there's a corporate entity that owns Pearl Bus Company. That's our client as well. And we're not doing anything in this matter with this client, but this is an active client, and this active client is Transport Incorporated, our client, and it owns Pearl. And Pearl is managed by the son and the president of Transport. So it looks something like this, and we have to figure out if we have a conflict. We have our old client that we talked about before, Dory Hathaway. And this is our firm, Shelton. Condenas, and we are suing Probus. It's another firm over here. But Transport Incorporated, active client. You know, we provide corporate information and filings, compliance information, just servicing the needs of that client. But this is our active client, and we're suing this bus company, and Transport owns Pearl Bus. So, we have to figure out, is this a conflict? So this says, assume the firm continues to represent Dory. We talked about getting rid of the husband. That was the other case. Her husband found a different law firm to represent him in the divorce. So we are the ethics advisor to this firm, Shelton and Condenas. We have to figure out what we are going to do. So our firms, and this isn't sort of structured to make it seem that we're a negligent firm. Sometimes mistakes happen. So our firm really doesn't pick up all of the corporate entities that we represent. So this is the situation that we're in. We are representing Dory Hathaway against Bus Company. That's fine on its face. They have another firm, but Pearl Bus Company is owned by our active client, Transport Incorporated. And on page 299 is the first, second, third really big paragraph that starts, you call Jason Kerr. We see all of this management and control of the company. That's in the fact pattern to show on some level how close Pearl Bus Company and Transport Incorporated are. Can we just say they're one entity, are they different entities, and how does that impact our analysis of the conflict? So it even says in recent years, Transport has had to take over many management functions of Pearl because the bus company managers kept making costly errors. You know, insurance coverage, management of the firm, finances, all of those things. And then Kerr says he's the president of Transport in our plan. Well, I guess it might be relevant that my son is the president of Pearl. He took over a couple months ago after we discovered that the former president was embezzling funds. And then he asks us, why do we need to know this all the way? Anyway, that's a question the client would ask. Well, you just represent me, that's okay. But we have to take a global view of this problem. Look at the top of page 300. So we have to figure out, so what are we going to tell our clients in Transport? What are we going to tell the president of Transport Corporation moving forward? And in the absence of informed consent from both clients, must we withdraw from representing Dory Hathaway, Transport, or both? So this asks us what type of conversation do we want to have? So what is going to sort of structure our conversation, I guess, is our analysis of 1.7. You got to ask those questions. And so you see how the rule can structure the conversation that you have in practice. And this is the discussion that we have to have with Kerr. So what do we want to say? We have to make an assessment about representation and offer that to our current clients. Our current clients are Dory Hathaway and Transport Incorporated. Is there a way to do the 1.7 analysis and have this discussion with Kerr? What do we want to say? So, you know, notice the way the book is set up. This is a joint representation in a civil context. What would we do? Then after that, we're going to do joint representation in a criminal context. So, how would you use, this is it, how would you use 1.7 to have this discussion? I mean, we have to talk about this with Dory too, but our most immediate problem is trying to figure out how to deal with the current client that we just spoke to. Is there a path forward to making this consentable and moving forward? What kind of things do we want to talk about with Kerr? You have to look at 1.7. You look at 1.7 and you do what? So you know, write it down. You can say directly adverse. Clearly limited. So these are concurrent conflicts. So what do we want to say about this? How do we want to frame this when we talk to the client? Yeah, sorry. Look it up.
I'm still confused because Hathaway's not suing the owner of the company, she's suing the company itself. So I'm still confused as to whether that still counts as directly adverse.
Well, yeah.
How far the current itself is.
So we did a discussion, that's true. We did a discussion on organization. We represent the organization, we represent Transport. We want to do everything in the best interest of Transport. Kerr is just the entity who helped, the person who helps move the policy of the Transport forward. You know, maybe closely held in that. So that's not really a problem. We may be in a position of suing our own clients. So how do we resolve that? We're not splitting them apart for purposes of this problem. We represent a client who's suing an entity that we represent. And we're talking to Kerr about that potential conflict. So what do we want to do? Yeah.
I guess you're not going to be able to represent her.
Yeah, well, not yet. That's good. I think you're right. I think you're, but work through it. Let's have this conversation. So we don't want to right off the bat say, oh no, we can't represent. We want to talk this through with the client. You know, there may be other business on the horizon. We want to keep a good relationship. We don't want to sort of be abrupt. But if we're going to reach that conclusion that maybe we can't represent her. We may not be able to represent her, and we may not even be able to continue the representation. That's a possibility as well. So the reason I slowed it down a little bit is I want you to sort of have that discussion, and that discussion is sort of going to evolve, and we're going to see how this whole thing might impact our two current clients. You know, this is really our client too if Transport owns Pearl. So yeah, this was good.
I think you could start by telling her that you weren't aware when you took this case, but that Dory Hathaway had sued Pearl, and that you didn't know at the time that Transport Inc. had purchased Pearl, and that you were calling to get more information to see how closely related the two organizations were, because you needed to flesh out this conflict.
Okay. And then from there. That's a nice way to sort of, we're working, trying to figure this out. We don't want to impact you or any other current clients that we have. This is why we're having this discussion. Okay.
And then from there, you start with 1.7A1 and directly at first. And so Jessica, Ms. Harper, was talking about how she didn't think that they were very closely related, but it mentioned that Kerr said that they've been paying the damages for excess verdicts that they got when they didn't have enough insurance coverage, and that Kerr's been covering the cost of the insurance policies. And so it seems like they are directly versed, but even if we think, like Jessica, that they're not that closely related, then you can move down into B and decide whether or not the representation, it would be on both sides of B.
That's good. That's good. So, you know, directly adverse, I think it's directly adverse even if it's unrelated. Look at all the facts we have. It's almost like Pearl and Transport. I put closely related, but there's this terminology that talks about alter ego. You have, you know, the president of the company coming in and doing all of these things on page 299. Takes over many management functions, shelling out thousands of dollars to cover damage. Transport is doing all this on behalf of Pearl. Increasing insurance coverage, taking over because of embezzlement of prior management. So there is certainly a theory that Transport and Pearl are closely related. And in fact, we could be suing our own client. And even if that isn't true, because we have this client, we may not do things that would be open to us if this wasn't our client. What about if we would have to amend the complaint after we find this out? I mean, we're still in Pearl business, but maybe the money is with Transport. So we could be directly adverse, or we could be materially limited. Because there may be things that we need to do for Dory that are foreclosed because of our current representation of Transport and Pearl. Maybe even going so far as to say we're on both sides of the V. So look, we don't even pass 1.7 analysis if we say, can we even really get past 1.7B1 where we say we reasonably believe that we'll be able to provide competent and diligent representation of each affected client? Some level, that answer is no. Because we'll be going against our current client on some level. However, we try to sort of rationalize it and distinguish it. The representation isn't prohibited by law, but we may be on the same side of the V. Particularly, we have to amend this complaint to include Transport. And even failing that, we are going to be materially limited because of the things that we may or may not be able to do on behalf of our client. So a number of problems. Okay, so maybe the smart way to do this is think about the money. What client gives us the most return? So we have all these conflicting problems and we say, oh, I don't think we can do this. Maybe we should consider getting rid of one of the clients. And we decide, let's just get rid of Dory. It's like her husband did, she can get another lawyer. Our big active client is Transport. Let's stay with Transport. And that's good. So we drop Dory. Can we do that? You know, another pressure that's in this, and I didn't even sort of push this, is that after we have this discussion that Ms. Walsh was describing, maybe our own client might get mad and move for disqualification. You just told us about this conflict. You're not going to do anything. We'll do it for you. So that's another layer. So then we look at Dory Hathaway. Can we get rid of Dory? Okay, this is certainly not as much money as this is and will continue to be. We found this conflict. One way to deal with it is to get rid of Dory. Can we withdraw from Dory and continue representing Transport? And one way to sort of rationalize this is that after all, we're not involved in this litigation and we're the corporate attorney of Transport. We'll keep our hands clean, we'll get rid of Dory. She doesn't give us that much return anyway to keep Transport. Yeah.
Well, she would be a former client, so you're still going to have to...
Okay, let's tell me about that. Now, what? We haven't covered this yet. You notice in all of these cases, we're sort of talking about former clients. This is just to sort of flag to you that in real life, you're going to have to, and for purposes of the NPRE and exam, sometimes when you have a current client, you have to look forward and backward. So this is an example of that. So everything, we have a current conflict now, we're trying to resolve it. And so if we get out of this, if we withdraw from Dory Hathaway to resolve the upper conflict in quotation marks. This is right. withdraw from Dory Hathaway to resolve the conflict, then she becomes a former client. Just give you a preview. This is 1.9. But tell me about that. What are you getting at, Mr. Johnson?
Well, so I guess depending on the fact that she had told you something that could be used against her in an upcoming lawsuit against transport, you wouldn't be able to use that against her. So that might affect your ability to represent transport.
Yeah.
In litigation.
Yeah, and they can find out, and then they'll be, well, we got this information, why don't you use it? She's a former client. You don't have, but notice, we have, even when we talk about Rule 1.6, 1.7, there is this continuing duty to preserve those confidences. So even though she's a former client, must preserve her confidences. And notice this, and there's an attaching duty, and cannot use this information to the former client's disadvantage. And if that's true, you may not be able to stay in using transportation because you cannot use that information to disadvantage Hathaway as a former client. And so you're going to be limited in the way that you represent transport. You don't represent transport in this particular litigation. The transport will say, why don't you help us in this so that we're not harmed financially. We may have to pay out a large recovery if we're unsuccessful. You have information that we can use. But you cannot use that information to disadvantage Dory Hathaway. She would be a former client. And we'd be materially limited in representing transport because of our prior representation of Dory Hathaway and the confidences that we received. So we could not really fully represent transport either. And so the result is that we probably have to withdraw from both. So that's an example looking at 1.7 and 1.9 together. So that's in the corporate context. But now, I don't know if we'll get through all three of these, but we have a series of cases and talks about representing co-defendants in criminal cases. Let me just say, so generally it's not a good idea to have joint representation, but we know in the real world people don't have money, they don't have access. In order to get an attorney, it may be necessary to have joint representation, but in the criminal context, that's much more complicated because a lot of things are at risk. The liberty interest, of course. You know, it's fine when we are united front, we're not talking to anyone, and we are standing against the prosecutor, but things fall apart all the time when people are faced with the real-life consequences of jail time, prison time. And so those things might change. So you have that liberty interest. You also have all these constitutional guarantees. You have the Fifth Amendment, privilege against self-incrimination. You have the Sixth Amendment confrontation clause. And so again, those constitutional guarantees are going to be complicated when you have a joint representation. And the book sort of starts off like that. If you look on page 300, that's what they're talking about. And you see on the top of page 303, the ABA guidelines for criminal defense attorneys strongly discourage joint representation in criminal cases, just because those common defendants can turn on each other. Look on page 306, it's interesting. So notice how important this is. This is whenever a trial court improperly requires joint representation, and the attorney is sort of objecting, no, this is a bad idea, we don't want joint representation in this criminal case, and the court does it anyway over timely objection, reversal is automatic and no showing of prejudice is required. So whenever a trial court improperly requires joint representation over a timely objection, this isn't a good idea, Your Honor. Reversal is automatic, no showing of prejudice is required. That's Holloway on page 306. So even if there is no objection, then the criminal defendant has to show that there was a conflict of interest that actually affected the adequacy of representation. But that's not the prejudice standard that we talked about when we were talking about the confrontation clause earlier under Strickland. Here we're talking about adverse impact, not prejudice. Now that duty to prove adverse impact is greater if no objection is made to the conflict. And you see that on the top of page 307, but we're still talking about adverse impact. And so that leads us to this set of criminal cases. There's three parts to it. But, and over and over again, we've been noticing this. Yes, conflicts are consentable, but there may be times when the conflict is so bad that even if you get, quote, informed consent, that's not going to make the conflict go away. And so, has anyone heard about this case or not? I hope not. Anybody heard about this? Okay, this is an actual case. This happened in New York about 15 years ago. So it's good to like heard about, so you won't know what happened. So there are a lot of players in this case. And what is interesting about this case is you have a number of layers of representation. And so in real life, you would have to figure out how do these layers of representation work? You know, what is the scope of representation? What does competence mean? Can this perceived conflict be navigated appropriately? And so we're going to start this problem on page 308, police brutality, first. And so there's an actual opinion about this after we get through all of this, a Second Circuit opinion that talks about this, pulls everything together. But we have Louis Austin. He's the victim. Started multiple times. All right. Well, pled guilty. This is a police officer. Pled guilty. This is the joint representation here. Chipstone. Facing charges. PBA. Their role becomes more pronounced as the problem progresses. Provide lawyers. So you see this development, this is like a third party that provides legal fees. So we have to make sure that the attorney-client relationship is independent of that, but that can cause some challenges. So that's another thing we'll look at. Provides lawyers for officers who face legal action. And also charge board member. And he has different representation. So you look on page 308, so this is how we start off. Several officers are charged with this brutal assault. You see that on page 308. We have Officer Babbage up there. He already pled guilty. But we are jointly representing, our firm is jointly representing Chip Stone and Bob Morton, another partner representing him, but I just put joint representation. PBA will pay fees if we represent Stone and Morton. You see that on page 309. If we agree to represent Stone and Martin, the PBA will pay our fees. But notice this is another level of this conflicts in a particular context. So you have to look at Rule 1.8F. And that tells us, yes, it's fine to finance that, but you don't have the ability to call the shots of the representation simply because you're providing money. You know, under the rules, the lawyer is independent in judgment. The lawyer is calling the shots on behalf of the client. So 1.8 states that a lawyer may not accept compensation from a third person unless the representing client gives informed consent. They will. Yes, they don't have any money they want PBA to pay. And there's no interference with the lawyer's independence of professional judgment or with the attorney-client relationship. Confidence is not protected. So in no way can this outside financing of the representation impact or influence our representation of our clients in any way. PBA can't come to us and say, well, what are you talking about? Just give us a general synopsis. I know you can't divulge any attorney-client confidence, but you can at least tell us the error. No. Or we think the defense should go this way. If you go down this road, you may be exposing the PBA to liability. That will become important a little bit later. But you'll be exposing us to liability. So we want you to change the argument a little bit this way, not present this evidence and present the witnesses in this particular order. No. So complete insulation of the attorney-client relationship from this outside influence, even though they are paying for the representation. And so, if our firm accepts representation of these defendants, we're going to represent them. What should we talk about? Let's say we know about everything that we've talked about in this chapter. We know that it's not a good idea really to do joint representation, but on some level there's no way out. They can't afford it. We're going to provide representation. And we know that the rules say even though a conflict may exist, that conflict is consentable. But in order to get that informed consent, we have to have a conversation. And that conversation could lead to a joint representation agreement. So what types of things would we want to talk about to formalize this agreement to represent Stone and Morton? Yeah. So we are representing them. We have to move forward. We have both of them in the room. So what do we want to say? Yes, go ahead.
I think the last one we did the joint representation, they had to agree that their competencies would be sure.
Yes. That's important. Anything else? That's really important. So notice what that does. You're saying, well, I'm not going to choose your story over this story. We're going to, at least at this point, okay. Anything else? This is joint representation discussion. Anything else? Yes.
At some point, if their interests diverge, excuse me, they may have to get independent counsel.
Yeah. That's good. Anything else? Yeah.
Well, based on what they did in the crime, their outcomes, even though you're representing both, like, their outcomes could be extremely different.
So that look,
Their outcomes could be different, like, based on what actions they took in the crime.
Okay.
So even though you're representing both, they both might not be the same.
That's good.
judgment.
Anything you want to say? Yes, Mr.
I think you might be limited in some ways that maybe if you were representing them in like one or the other, but representing them both, you might be limited.
Mm-hmm. Yeah.
Do we have to tell them that there's a potential that, like, if there is a conflict, the judgment can be overturned? Or do we have to tell them that?
Well, you sort of cover it here.
Okay.
And so that's pointing to a problem that we may have. Is it even really consentable? But I don't think you can sort of insulate yourself by saying, well, this is a conflict with all these problems, and therefore the judgment can be overturned, and that's fine. We're sort of, that's going to come up a little bit later, but we're sort of saying, if we do try to move forward with this, what type of things should we discuss? Anything else? Good, let's take one more. Maybe tell them clearly that the PBA does not control the representation. The firm represents Stony Morning. Okay. So this may come back and haunt us. This is a question that some of you have highlighted in some of your comments. I think the two major things in this joint representation discussion is that at some point the interests may diverge, and there may be some things that we can't even consider because we're representing both. I mean, we can't say, well, make a decision, we want Bob Morton to get off, and to do that, we're going to have to do some things against you, Chip Stone. Do you still agree with that? That's something that probably is not considered. So that's what drives this problem. Yes, it is. So that's the first of these possible conflicts. So we have Alston in our problem. He's the victim. He's saying that at least one other officer participated. Do we know who that is? One defendant may point at the other defendant, or maybe it might be Tom Gutman. That's going to open up some conflict issues as well, because keep in mind he's a suspect. He's on the board of the PBA, and he may have participated, and PBA is paying our fee. So if it's just one of our clients, we might be helping the prosecution prove a case against another. That's something to consider. You cannot aggressively cross-examine without hurting another client. So there's some things going forward that might hurt one client over the other. And still we have a PBA looming. So we're asking ourselves this question over and over again. Are these conflicts so serious that we might not be able to represent both of them? And we know that that's an objective standard. And I don't think we're at that point yet. On page 309, where we say, are these potential conflicts so serious that your firm must not represent both? If we have this discussion with them, and we get informed consent, we can move forward. But notice what we say here. If interest diversion, independent counsel may be necessary, we are recognizing, when we say is this conflict consentable, we're recognizing that things may change. So as we progress through this problem, things are going to change. Look at, on the bottom of page 309, scene 2. Now things are going along, and there's going to be a civil litigation as well. This is Alston against the PBA. And this civil litigation is based on PBA's policy of a code of silence. So we have the civil litigation as well that we have to think of, as well as the criminal defense that we are doing. And Babbage's lawyer has told us that Babbage has told the police and prosecutor that he can't remember who the other assailant was. So each of our clients tell us, no, I wasn't the assailant. Neither wants to testify. And that's obviously probably from advice from the PBA. We have the civil suit, and we know that Alston is alleging that there's this policy of a code of silence. See that on the bottom of page 309. PBA has engaged in misconduct. There's an enforced code of silence among officers. And there's even a component in the police department guidelines that says a union member of the PBA cannot talk about the incident for 48 hours. So obviously you know what that does. That allows a position to be crystallized, a defense to be put in place, and evidence becomes less relevant and obtainable when you have a two-day head start. So look at the top of page 310. Shortly after this, PBA offers our firm a 2-year contract worth $2 million. So not only are we representing Stone and Morton, but notice this, PBA offers firm what is essentially a $10 million installment contract to represent all PBA members. So notice that we have this lucrative deal that's connected to our representation. We not only represent Stone and Morton, we represent potentially all members of the PBA. And PBA itself in any litigation, including the Alston case. So they offer us this $10 million